Look, a lot of cops do not understand arguable probable cause and the collective knowledge doctrine. All right, let's talk about it. So the arguable probable cause is a standard that's used mostly with search warrants, even though, Mike, I have seen it used with warrantless arrests, which I personally don't like because it's usually held to a higher standard. But arguable probable cause is this idea is that if the officer has a warrant and let's say a search warrant, and when we go to a suppression hearing, the court does determine that search warrant is deficient. Oh snap, that's way too much for me. Is deficient. Mike, do you want to get on the? Is that Mike's quote? I can't see the whole thing. Hey, Mike, do you want to get on? Do you want to get on the? Let's get you on the mic. Mike, can we turn on your microphone? All right, let's talk to Brave.
Yes, sir.
All right, what you got?
Well, where these came up was I was sitting in. I'm an expert in a particular case, and I was sitting in on the deposition of plaintiff's expert, who's nationally known. Everybody here would probably likely know him. And it was interesting that when he was trying to defend his so-called opinions, he did not even know what arguable probable cause was, nor did he know what the collective knowledge doctrine was, and therefore he said they didn't apply and he couldn't apply them because he had never heard of them before.
Wow. Now, is he a cop and attorney, or what's his I don't even know his name, but what's his profession?
He was a police officer for a few years. Now he's a PhD living in academia. But he's doing an awful lot of expert witness work around the U.S. on use of force as well as search and seizure.
All right. Well, look, the way I explain arguable probable cause, Mike, and you tell me what view you take on it. But again, mostly for search warrants, right? Arrest warrants, search warrants, mainly for search warrants.
Can I shorten this for you?
Yeah, please do.
The whole point is, in order for an officer to arrest someone, et cetera, they have to have probable cause. However, to have civil liability against them, the standard is only arguable probable cause, meaning you still have to have the probable cause in order to arrest, et cetera. However, in order to get beyond the civil threshold of liability for the officers, that standard is arguable probable cause. That's the distinction.
And I think that helps because it's like, even if the charges were dropped, even if the prosecutor says, hey, look, we're not going to move forward with these charges because there's no probable cause. If the cop had argued probable cause, then civilly they don't pay money, correct?
Yes.
Now, arguable probable cause is basically where it almost, the way I read it, it's like, I mean, maybe I'm exaggerating here, but it's almost like the court says, if any reasonable officer out there could have thought that this was probable cause, then we don't pay money. Is that close?
Yes. Basically, Malley versus Briggs said that officers' opinions can differ. So therefore, as long as the probable cause is arguable, even if in a judge's chambers it is later determined that they did not actually have probable cause, the officer still gets qualified immunity and does not face civil damages.
Yeah. Now, I personally like arguable probable cause used in the context of search warrants. I've seen it more. I've seen out of 10 cases I've seen where they mention arguable probable cause, 9 of them are search warrants. Is that something you have also observed?
Yes.
And I like that too, because we always want to give officers more leeway when they decide to go to a judicial, they get judicial approval versus doing things on their own. However, you do bring up a good point. We're not talking about criminal charges. We're not talking about, at the end of the day, if the cop did not have probable cause, let's say, technically speaking, they did not have probable cause, and let's say we arrested the person and search, instant to arrest, they find drugs and so forth. Yeah, maybe the consequence is that, the criminals to go free because the constable blundered. But we're talking about money exchanging hands, and arguable probable cause is really about not penalizing an officer who made in one way, a good faith mistake. I guess that's one way of looking at it.
Yes, you could also compare it to mistake of fact shootings. Somebody produces what the officer believes reasonably perceives as a firearm, and the officer shoots him. It turns out to be a wallet or a phone or something. That's a mistake of fact shooting. It's literally the same thing. There's the thresholds of law allow the officers to make those mistakes, especially under stressful conditions under totality of circumstances.
Yeah. Now, one thing. Okay. So look, the arguable probable cause, I can understand that some people, if you're getting paid expert witness money and you have, yachts and airplanes like you do because of the money you make on expert witness stuff, I understand you should know what arguable probable cause is. But what about collective knowledge doctrine? This expert witness did not know what collective knowledge was?
Correct. He had never heard the term before, and in this case, that was key because it was an officer-involved shooting, and basically there was a lot of information that a lot of other people had, including this person's background. And the plaintiff's expert said that's all irrelevant because the officer did not personally know it. And when he was asked about the collective knowledge doctrine, he'd never heard of it before, even though I think he first served as a police officer, I don't know, 15, 20 years ago. And then he went on to academia after that.
Now, some people know collective knowledge as the fellow officer rule. You've heard of that too?
I have, but there's one distinction you need to be aware of is that it usually applies to encounter, stop, frisk, and arrest, which is usually where the collective knowledge doctrine applies, including with dispatch, of course. The problem is there's only 1.5 circuits, meaning federal circuits, meaning there's only one where it's actually been held to be appropriate in the use of an officer's use of deadly force. And in the Second Circuit, not the Second Circuit, but a Second Circuit, there was one case that quoted the 11th Circuit that said it could be used, but it said that this circuit has not adopted that yet, but here's a circuit that did. So the point is collective knowledge doctrine, encounter, stop, frisk, arrest, you're probably good to go. If it comes to attempting to use that to justify the use of deadly force, you better hope and pray you're in the 11th Circuit if you do that. Because the Ninth Circuit specifically said that they have not adopted that.
Yeah. Look, there's some politics there too, giving somebody a pass because of shooting somebody when in their mind it wasn't justified. It shouldn't have been justified objectively, but then having another officer somewhere on scene saying, hey, I could have shot him. Right?
Let me flip that a little bit. Officer A screams, my God, he's got his gun. He's got a gun. He's about to shoot you. So you shoot him. Even though you did not justify that in your own brain with your own observations that he was about to shoot you, so therefore you can shoot him. You're totally basing it off another officer's statement, and that's where this is likely to come into play in certain circumstances.
Yeah. Okay. So Gerald says his wife is vacuuming. That sounds like my wife. My wife is a perpetual vacuumer. All right. Well, look, that's interesting. No, and so I'm glad you came on because look, so the lesson of the day right so far is arguable probable cause. It is a civil standard that basically helps our officers when they don't necessarily have probable cause. They can also say that, hey, look, you still don't pay money because you have arguable probable cause, and collective knowledge doctrine, which is a very common police doctrine.